system for electronic transactions without relying on trust. That is how the blockchain and cryptocurrency was described by the pseudonymous Satoshi Nakamoto, the creator of Bitcoin, in the 2008 white paper. But can we trust cryptocurrency? It was a world designed to democratize ownership and give back financial control to the people. And it is now a financial ecosystem that thrives beyond the bricks and mortar of banks and financial institutions. Yet within this exciting system of digital wealth, a sinister undercurrent and growing wave of crypto fraud threatens to undermine the very promise of a decentralized and trustless economy. The 2023 Chainalysis Crypto Crime Report stated that approximately $3.8 billion was stolen from various services and protocols in 2022 alone. And there were an estimated $20 billion worth of illicit crypto transactions. That's more than any other year. My name is Jessica Lee, and I am a litigation partner in the London office of Brown Rudnick. My practice includes civil fraud, asset recovery, and commercial litigation with a particular focus on digital assets. In the next 10 minutes or so of this video, I will delve into the murky world of crypto fraud and give an overview of the cutting-edge strategies that are being developed and deployed by fraud lawyers and practitioners in this area to recover stolen crypto assets, and where practitioners should proceed with caution because uncertainty still reigns. So how have the English courts dealt with cryptocurrency fraud cases so far? I think it's fair to say that the English courts have demonstrated a willingness to assist victims of crypto fraud and also apply old law flexibly to novel ideas and novel technology. For example, the courts have accepted that crypto is capable of constituting property and have also found jurisdiction and applied English law to crypto fraud cases. In terms of tools for asset recovery, the English courts have, in crypto asset fraud cases, embraced worldwide freezing injunctions and proprietary injunctions, disclosure orders such as Norwich Farm Call orders and Bankers Trust orders, even going so far as to introduce a new procedural gateway to enable third-party disclosure orders to be served out of the jurisdiction in order to discover the identity of a wrongdoer and the whereabouts of misappropriated assets, including crypto assets. And that came about as a result of a wave of crypto fraud cases coming through the English courts. The English court has also allowed service of court orders and claims by airdropping an NFT into a known wallet address, which was held by persons unknown in a number of cases now. In obiter comments in the case of Wang and Darby, the court also suggested that crypto assets were capable of being held on trust. In terms of enforcement, there have been a couple of cases now involving third-party debt orders and delivery up orders, which have enabled a victim of crypto asset fraud to enforce an English judgment against a foreign crypto exchange. And in the case of a third-party debt order in relation to an English-based crypto exchange. But all of what I have just said comes with a word of caution. Many of these decisions are uncontested and therefore have not been challenged. And there are limitations that apply, which practitioners and claimants alike should be aware of when seeking redress in crypto asset fraud cases. Now, I'll come on to discuss some of those very briefly. But before that, it's worth delving into a couple of very novel and creative asset recovery solutions that have been explored in the English courts so far. First is the case of tulip trading. Many of those watching this video will be familiar with that, but there the claimant advances a novel claim in which they seek an order that core developers of various Bitcoin networks effect amendments to the software in order to allow the claimant to recover access and control to their wallet containing Bitcoin, which they are no longer able to access because their private keys have been stolen through a hack. It claims that developers of the Bitcoin networks owe fiduciary duties to implement changes on the network. And that is a very closely watched case because it potentially opens up a new avenue for recourse for victims of fraud, but also potentially raises some eyebrows in the blockchain industry as to whether or not that in practice could be ordered and whether it could potentially threaten the blockchain industry as a whole and the ethos underlying it. Earlier this year, the English courts also had a case involving ethical hacking. So this related to a $321 million exploit of a DeFi protocol, and assets were then moved through a decentralized platform. And the applicant in that case, who was the decentralized platform through which the stolen assets had been moved, applied for an order which essentially asked the court to permit it to undertake a counter-exploit together with a Web3 infrastructure firm in order to hack its own protocol to recover stolen assets. Again, I'll come over to some of the issues that gives rise to. But taking the crystal ball and gazing, forward and looking at what might be coming down the pipeline, but which I don't think we've seen yet, or I'm not aware as at the time of this video that these cases or claims have been advanced in the English courts. First of all, Quint's care duty. Could you possibly have a claim against an exchange that they owe a duty of care to exercise reasonable skill and care in executing a payment transaction in crypto? Now, we know that Quint's care duty has been applied to banks. Question I ask is whether this could be applied to crypto exchanges. Now, there are many different factors, and I think given the typical lawyer answer, it would depend on the facts and circumstances of a particular case, but that could be a potential avenue for recourse for a crypto fraud victim in the future. There's also obviously potential contractual claims under terms of use against exchanges and potential tortious claims. But moving back towards that duty of care type claim, that is something that we have seen come up in a US case recently. I don't think anything like this has been argued in the English courts yet, but earlier this year, a recent decision came out in the Californian courts in a case called UkiDAO. Now, UkiDAO was a decentralized autonomous organization. So essentially a software protocol through which the governance and decision-making is automated and decentralized. And DAOs or decentralized autonomous organizations are used to operate DeFi platforms in the crypto space, NFT projects, and even for philanthropic causes. So they have a real wide range of application. And so this case is of interest because the findings in that case could equally apply to DAOs being used throughout the crypto sphere in crypto fraud cases. So there, UkiDAO's protocol was subject to a hack, and users who had lost assets through that hack brought a class action in the US courts seeking to hold the DAO and its members liable. And the US court, this was a sort of first instance decision, an initial application in the US courts. The US courts considered there that the DAO was an unincorporated association or general partnership, which gave rise to specific duties of care and responsibilities to the users of the network, and also potentially unlimited liability for the DAO and its members. Specifically in that case, the DAO's governance token holders, so those that had the ability to vote on particular decisions. But while the English courts have demonstrated a willingness to assist victims of crypto fraud, that is not without limitation. In the recent case of Pirazada, Binance applied for the discharge of a freezing injunction against it in relation to assets which had been the subject of a crypto fraud and which had ended up in Binance's hot wallet. Now, that case is an important reminder not only of the duty of full and frank disclosure, but also a reminder that one size does not fit all in this industry. There are nuances between the inner workings of crypto exchanges and therefore the type of relief that may be obtained in any particular case, depending on the facts and circumstances. Case law in this area is far from settled, in my opinion. If you look back to one of the basics, jurisdiction and governing law, in which there have been several cases which have found English jurisdiction and applied English law, those have all been uncontested. And even those cases where the courts have looked at whether English law should be applied to the dispute have found jurisdiction and applied English law on different grounds and applying different factors. There are also a number of cases against centralised exchanges which challenge arbitration clauses and jurisdiction found on arbitration clauses. And all of this, I think, stems from the very nature of crypto assets. They are borderless, they are decentralized, they permeate many jurisdictions, and therefore it presents unique challenges when it comes to establishing jurisdiction and applying any particular governing law to a dispute. And that is also going to be the subject of a Law Commission consultation later this year. So I think on that basis, we can say that this area is far from settled. Going back to some of the examples that I gave earlier in terms of novel strategies that have been deployed in crypto asset fraud cases, tulip trading, that has only been decided by the Court of Appeal on the basis of a serious issue to be tried. And there, Lord Justice Burrs, who delivered the leading judgment in that case, was keen to recognise that for Tulip's case to succeed, this would involve a significant development of the common law on fiduciary duties. He mentioned that the conclusion is not that there is a fiduciary duty in law in the circumstances alleged by Tulip, only that the case advance raises a serious issue to be tried, and that the time to decide on the duty in this case is once the facts are established. Now, that case will go to a full trial with factual and expert evidence on both sides, and only then may we have some clarity over whether or not fiduciary duties might be applied to developers in this area. But even taking a step back and going back to the philosophy of blockchain, the very notion of the English courts requiring the modification of a decentralized ledger potentially threatens key principles underlying blockchain, including immutability and decentralization. So query whether, even if tulip trading was to succeed, whether the order that the claimant is seeking could even be implemented in practice, or would even be implemented by users of the network who would have to agree via consensus to implement that software change. Similarly, in the Jump, Crypto and Oasis ethical hacking case, that begs the question of how a supposedly decentralized platform was able to retrieve crypto assets from its users by hacking them. Now, there, the platform was keen to emphasize, and it publicized this on a blog post and on Twitter, that it was only possible due to a previously unknown vulnerability in the design of the admin multisig access. Essentially a vulnerability that had been highlighted by white hat hackers. Now, good moral hackers who try to tell people where their code is likely to experience vulnerabilities so those platforms can take actions to close those gaps. Now, that sounds like it could be a one-off case because of the particular circumstances in that case. There just so happened to be a vulnerability in the code which allowed the platform to hack back the assets in a counter-exploitation and recover some of those stolen assets. I don't think it's something that we could expect the court to be ordering in a flood of cases going forward. And in any event, I think it could set a controversial precedent because it's, ethical hacking is liable to misuse. Cybersecurity risks remain prevalent when you're hacking. And there are obvious technological and privacy concerns that arise. So to conclude, in the realms of both the physical and digital world, trust remains one of our most valuable assets, and crypto fraud threatens to undermine this ecosystem's foundational principles of trust. I don't think that should be an indictment of the technology, but more a reflection of human nature. But it is comforting for me, at least, to know that the English legal system and those that work in in it are striving to create asset recovery strategies to ensure that this nascent industry is where innovation can thrive, freedom can flourish, and trust can endure.